Broadcast is now starting. All attendees are in listen-only mode.
Good evening. My name is Janice Mathis. I'm Executive Director of the National Council of Negro Women, and we're delighted that you've chosen to spend some of your precious time with us this evening to talk about a subject that is not very sexy, but it's something we will all need to deal with one way or another at some time during our lives, and that is estate planning. We will get started in just a few moments. We've got a wonderful guest, Valerie Carpenter Lurie, who's here with us this evening. We'll finish introducing her when we come back. Folk are still signing in, so we'll wait just a couple more minutes and then we'll be ready to begin. Okay, looks like most folk have signed in already, so we will get started. Tonight's webinar, as I said before, is about estate planning. And it's just going to give you some basic tips and ideas and things that you need to think about as you create your own individualized estate plan with your lawyer. Tonight, we are so fortunate to have with us an experienced practitioner in the field. She told me that she really practiced more real estate law, but found out that estate and probate law was an essential part of her practice. And so she branched out into that area. She is familiar perhaps to some of you who live in what we call the DMV. She is Valerie Carpenter Lurie. She is a magna cum laude graduate of HU, you know. She is a member of Phi Beta Kappa. She earned her Juris Doctor from the Georgetown Law Center here in Washington. She is a member of the United States Court of Appeals, the PG County Bar Association. She's a master with the Thurgood Marshall American Inn of Court and a delegate member of the 36th Annual District of Columbia Judicial Conference. She's a member of the Maryland State Bar Association, the DC Bar Association, the American Bar Association, the American Association of Trial Lawyers, and the Washington Bar Association. She is eminently qualified, and I am so grateful, Valerie, that you could join us tonight. We traditionally do this program in January, and you might say, well, why is that? Because January is the month of new beginnings. We all make resolutions. We're going to lose that last 10 pounds. We're going to exercise more. We're going to eat better. And this is one of the things that we need to add to our list. We're going to create an estate plan so that when the inevitable happens, we don't leave our affairs or our friends or our families in disarray. And even more importantly, we're able to carry out those desires after our demise in the way that we would want them carried out and not leave them to chance or to circumstance. Mr. Johannes, do you want to give us Mr. Johannes is our esteemed communications director for NCNW, and he may have some tips that will help us navigate the webinar platform. Mr. Johannes.
Yes, ma'am. Hello, everyone. If you look to your right on your computer screen, you will see a control panel. Below, you'll see a couple of tabs that can be expanded. One of them is handouts. We have given you a handout on how to operate the GoToWebinar or GoToMeeting software, as well as the PowerPoint that we'll be using tonight. If you have a question, we'll be going to questions at different times, and definitely near the end. You can type it in on the expanded screen that says questions, and we will ask our guest and Evie Mathis. You can also, when you do that, you can raise your hand by hitting the little hand button on the top left. If you have any questions other than that, please feel free to email us at ncnw_HQ@ncnw.
Okay, we're going to start with the PowerPoint presentation, but I want you to feel free to raise your hand if you have a question or submit it in writing as a text message to us, because we really want to make it interactive. And Ms. Carpenter-Lurie and I will sort of go back and forth with the slides, but we'll stop periodically to give you a chance to ask us questions and hopefully get some good answers that will be of use to you. This is a part of the NCNW Information Series. The Women's Empowerment Program is funded in part by the Coca-Cola Company. Some of the subject matter that we expect to cover this evening, and we won't cover it in great depth because we only have about an hour and 15 minutes, and you can spend months talking about this, but we'll talk about what an estate plan is, what is a will, what is its purpose, what does it achieve, what are some of the procedures in probate, what is probate, what is intestacy, what are some ways that you can avoid probate. I'm sure that many of you have heard that you can avoid probate by taking certain steps. Who are my heirs and beneficiaries? What is a trust? When is a trust appropriate? And maybe what are some of the different kinds of trust documents that are available. And we'll touch just a bit on plan giving and give you some tips on where you can go to get additional information. The purpose of this webinar is to explain a few of the basic principles and procedures associated with estate planning, wills, and probate in estates. We hope to alert you to issues you should consider in order to avoid the pitfalls of not having an estate plan. We will explore the considerations in making a will and discuss some of the alternatives to probate. Once you finish the course tonight, you'll have some familiarity with basic estate planning concepts and terminology, including the will, trust, power of attorney, heir property, and more importantly, understand how important having an estate plan is to effective property ownership. Valerie, would you like to make a comment before we get into more of the meat of the discussion?
No, I think that it's important that everyone realize that without an effective estate plan, it could lead to a lot of problems after you're gone for your family, for your spouse, if you have one, for your children. So it's very important that you understand the importance of having a plan.
Thank you for that. I think that's very important. And let's talk about what is a plan. It's a process. It's designed to ensure that, to the extent allowed by law, your desires for the distribution of your assets and property and for the carrying out the payment of your debts after your death are carried out. And some elements of that plan might include a will or trust. There's something called intestate succession, which is a fancy term for dying without a will. You often hear celebrities on television advertising reverse mortgages, and there are pros and cons to those. People often prepare powers of attorney. The one caution I would advise is that powers of attorney have no effect after your demise. You can have a perfectly valid power of attorney, but once you close your eyes, that power of attorney is no longer valid. Of course, there are health care powers of attorney and living wills, and it's always important to consider the financial condition, your own financial condition. What is it that is likely to happen? What events or circumstances are you trying to manage with your estate plan? For example, are there minor children or grandchildren that need to be considered? Is there a disabled spouse? Are there charitable causes that you want to take into consideration? All of these are elements of an effective estate plan. Estate plans can be effective in helping to limit certain kinds of tax liability. Although the inheritance tax limits are relatively high now, so most folk, unless you're fairly wealthy, don't have to worry too much about estate tax. But having an effective estate plan does save your heirs and your beneficiaries, your loved ones, and your next of kin a lot of trouble, money, and time, and even heartache. And of course, a plan helps to preserve your estate assets. It's one of the greatest gifts that you can give to a spouse or children. They will be bereaved enough when you depart without having to worry about what must I do, where will I find the insurance documents, what should I do about the house, do I need to pay off the reverse mortgage? You want to make it as easy and smooth a process it can be, given that it's an emotional time for many in the best of circumstances. What can estate planning do for you? Provide for your family, obviously. Get property to beneficiaries quickly. Plan for incapacity, especially with some types of trust. Minimize the probate expenses. Choose the executors or trustees for your estate. This is important. Help a favorite cause, your church, your sorority, some other organization or cause that you care about. Make sure your business continues to run smoothly. Valerie, I want to stop and give you a chance to comment. Perhaps you could give us an example of when you've seen an estate plan or the lack of a plan affect a family's circumstances.
I think that one of the things, and I was alluding to it earlier, is that if you don't have a plan, if you specifically don't have a will, it can lead to a lot of problems if especially siblings don't get along during your lifetime, and then there becomes a fight over your assets. And I've seen it time and time again, and basically a lot of your estate is then dissipated in legal fees because it's the estate that has to pay the lawyer in the long run. And I've seen that a lot. And I think that that is one of the most important things, that you leave that will, which is a guide to how your estate is to be distributed, and hopefully minimize any adversarial processes over your estate.
Well, I think that's so true. I remember a case many years ago. I was a young lawyer, and a gentleman came into my office and he wanted to make a will. He had, several children, and maybe 7 or 8 of them, and all were boys except for one daughter. And he decided that since his daughter was very trustworthy, he would leave everything to her, and then she could in turn decide how to distribute among her brothers. What he didn't count on was that she had a husband, and the husband convinced the wife, the daughter, not to share any portion of the estate with her brothers. They were terribly disappointed, angry. It caused all kinds of friction in the family. But this is just one example of how things can go badly wrong if there is not at least a basic will. Things you need to know before you become a widow. How much life insurance is there? What are the company names and policy numbers? Now, let me say that these questions are not necessarily tied to a will. You can have life insurance, obviously, without having a will, but they often come up in the context of a death or transition. And so often these questions get sort of mixed in to the overall scenario of what is going on with you or with the family. Where are the life insurance policies? Who are the beneficiaries? Where is the bank, the brokerage? the retirement accounts, just the basic inventory. Is there a safety deposit box? Where's the key? What are the addresses and phone numbers for the next of kin? Who is the lawyer? Where is the will? Is it in a safety deposit box? Is it tucked away in a safe in the home? How do you find the necessary documents? I want to stop for just a minute and see if there are any questions from the audience at this point. Mr. Johannes, if you would remind folk how to raise their hand or type in a question.
Yes, on the control panel below, there is a question tab. It opens up and you can type in your question, and then you can hit the raise your hand button. You'll see a little orange hand on the top left side. But the questions we have is, will this session be recorded? The answer is yes. It will be recorded, and then it will be added to the NCNW website at ncnw.org.
Thank you for that question. If there are no others, we'll proceed and we'll stop again in a few minutes for additional questions if there are any. According to one lawyer, the last will and testament is one of the most important elements of estate planning, and I think that is self-evidently true. A will is the primary document that should be prepared while living, and it's only effective at the death of the person making the will. It is a written document. Usually it must be executed in the presence of witnesses. Usually those witnesses should not be children of yours or beneficiaries or kinfolk. It ought to be somebody who, in the law, we say is disinterested. In other words, somebody who does not stand to inherit, because you don't want to raise any questions about whether or not there was undue influence over the will maker by the witness. The person making a will must have testamentary capacity. Generally, that means over the age of 18, of sound mind, and mentally competent. Valerie, let me ask you, what are the procedures for executing, that's what we call signing a will, executing a will in Maryland or in DC? What does that look like?
So in both jurisdictions, you need two competent witnesses over the age of 18. And one thing I want to add, I've had people come to my office who've gotten wills online, and not to say that some of them don't work, but unfortunately I've had instances where they thought just notarizing the will was sufficient, and it is not. At least it's not in DC and Maryland. You actually have to have two witnesses. And so I've had the unfortunate, some of my clients unfortunately thought that they were doing legitimate wills, and they die and their relatives come in, and I have to tell them, the will is not going to be admitted into probate because of some deficiency. So I think it's important probably to see a lawyer and let a lawyer help you, because it is an important document and you want to make sure it is going to be admitted to probate if it has to be admitted to probate in court.
That's a very important point, and I'm glad that you raised it, because I too have seen that situation where, we want to save a few dollars on the front end, and then we find out, or our families find out later, that what we intended does not actually occur. Most wills include, of course, the name of the testator or testatrix. That's the person making the will. It has some provision for how real and personal assets will be distributed. And by real assets, we simply mean real estate. Provision for payment of debts. I've had clients who wanted to inherit, but they didn't want to pay the debt. Executors who wanted to distribute the property, but pay no attention to the debt. Well, it doesn't work that way. If you take the property, as a general rule, you have to take the debt that goes with it. The mortgage goes with the house. The note goes with the car. Often there will be burial or cremation instructions, the appointment of a personal representative, and this goes by a lot of different names. It can be an executor, trustee, sometimes a conservator if there is no will and there's assets, and sometimes for a minor or incapacitated adult. And provision for underage beneficiaries. Sometimes there might be a contingent beneficiary for distribution, or there might be alternative personal representatives or executors appointed.
You have a couple questions on wills.
I have a couple questions on wills where we can stop and take those now.
Okay, one of them is our wills were done on a military base. Is it better to update every couple of years, or does it matter?
I don't think it matters if nothing has changed with respect to your family composition or your desires as to what you want to happen to your assets after you die.
I agree with that wholeheartedly, Valerie. I think the important word is what you said. Has your family circumstance changed? If there's been a birth or a death of somebody close, or a marriage or divorce, then that's the time when you really want to make some adjustments, or at least get your will out and take a look at it and see if it still makes sense to you.
All right, the other question is, if you have a will, must it be filed in court?
Most courts don't actually take the wills until death. There are some, however, that will allow you to register the will. The only issue with that is if you decide to change your will, which you have the right to do as long as you're competent to do so, then you have to then pull the will back from the court. So I don't know. I think that the important thing is that someone knows where your will is, where to find the original will if something happens to you. And I want to address this issue about the safety deposit box. Some people put their important papers in a safety deposit box, and then no one has access to it. So you have to be very careful about that, because your heirs won't be able to get into that safety deposit box to even get the will without starting a separate kind of probate situation before they can actually file the will and honor your wishes. So be careful about that.
That is absolutely true. I have had to get court orders to saw open a safety deposit box because nobody knew where the key was. And so you have to get a court order to have them drill a hole in the safety deposit box so you can open it. And that's not what we want to do. Any other questions, Mr. Johannes?
Yes, if someone passes and you take the house, are you liable for the person's debt, such as credit cards, etc.?
So as long as there is an asset that is available to pay the decedent's debt, those debts have to be paid. They come first. There are obviously allowances for the spouse and things like that, but the debts have to be paid. You can't distribute the real property without making sure that that is taken care of.
Okay. We have a question that says, what is the difference between a will and a living trust?
Well, we'll both take a crack at it. It's not all that simple to explain, but let's see if I can talk about a trust. Think of a trust as a basket, and the basket has certain kinds of protections. It has privacy associated with it. It has features that don't require you to go to probate court to prove that the trust is valid. It can have provisions that are effective during your lifetime. And so a living trust can be effective while you're alive, and then it has different provisions after your death. A will is typically offered for probate, is not necessarily private. A will has no effect during your lifetime. And so it's different in the way that it is managed. The management of an estate with a will is different than one with a trust. With a will, there will be a certain amount of probate court oversight. Typically with trust, you may not have quite as much of that unless there is a dispute. Valerie, how else can we distinguish wills from trusts?
I agree. Basically, with the trust, you're transferring your assets into the trust during your lifetime. You continue to manage it. And then, presuming that you've put all of your assets into that trust, then there may not be any need for probate, because you dictate what happens after you die, who takes control, and what happens with the assets.
I think one of the advantages of a trust is that you can make provision for what happens with the income from your person. Suppose you got rental property and that property is earning income. You can designate in a trust how that income is to be used, and are there limits on it? And does it go to your children when they reach certain ages in ways that are a little bit more flexible than what happens with a will that doesn't have any effect until your death? Are there any other questions?
Yes, one question is, what is the basic cost of it?
I leave that to Valerie. She knows this market better than I do.
The basic cost of what?
A will.
A will? Well, actually, wills can be very, very simple, meaning all you're doing is saying, if you're married, if I go, then my spouse gets everything, and then if he goes before me, then my children get everything. That's a simple will. You know, lawyers charge different prices. I mean, that could be just a few $100s, but there are some circumstances where people have very complicated wills. They have a lot of people that they want to leave specific bequests to, or they decide that they want to create a trust within the will, which is an option that people have. And so in that case, you may have, let's say you have minor children, you don't want to do a separate trust, you put a trust in the will, but obviously the children can't inherit things directly, so you have to name a trustee and then give instructions in that trust with this, which is within the will, as to how the money is to be spent. So that can get expensive. So it all depends on how complicated your document is.
Speaking of complicated, this person writes, my husband's will was executed in VA, but he died after he moved in Texas. Do I have to let the courts in both Texas and VA know? We have land in VA and real property in Texas.
You want me to take that? So basically, a will is probated where the person resides at the time of death. And if there are assets somewhere else, there is a system for doing a foreign estate, but that state doesn't necessarily administer the estate. You just have to file a document saying that you've been appointed wherever he died, and then that gives you the authority to then dispose of property in a state where he did not die or did not live. Sorry.
Mm-hmm.
Does a will
Thank you.
Does a will always have to go to probate? Under what circumstances does it not have to go?
The will has to go through probate if there are assets that still exist at the time of death. So if there's a piece of property that's only in the spouse's name, or a bank account only in the spouse's name, then you have to go through probate.
And in some states where they have tenants in common, which people own property together, the spouse does not automatically, even if both spouses' names are on the deed to the property, that does not mean that the deceased spouse's share automatically goes to the surviving spouse. In some states, you have what they call joint tenancy, where there is an automatic transfer to the spouse at death. But in those states where you do not have joint tenancy, even if both names are on the deed, that will have to be probated.
Which leads to the next question. Can you put a home in your will if you still owe a mortgage on it?
Yes. Yes.
All right, here's another tongue twister. My husband has a daughter from a previous marriage. He designed it so she's entitled in our will already. Would she be entitled to anything more than what is allotted in his will?
She could be, but it would most likely involve a contest of the will. Let's say, for example, that it's only the widow and the daughter. In many states, they would be entitled to half the estate each. If the bequest to her in the will is less than half, she may opt to try to contest the will rather than take what is given to her in the will. But there are ways to handle that in the will drafting that minimize that possibility. In other words, you can say if you contest this will, you lose everything. And that has a way of dissuading people from challenging the will.
I think you've already
Right.
the next question, but I just want to be sure. It says, if you have student loans, do they have to be paid off from your estate?
Oh, I certainly hope you get to pay them off before your will is probated, but given the size of these student loans these days, who can say? Valerie, what do you think about that?
Yes, yeah, all your debts have to be paid if you have assets.
Yeah.
So debts have to be paid before distribution to heirs, except for statutory provisions for a spouse. Some states have a provision where a spouse gets, you know, $15,000 or $10,000 if that's available before anything has to be paid to a creditor. But creditors have to be paid if there are assets in the estate.
Georgia, where I practiced for a long time, has a unique procedure called a petition for a year's support. And it is fairly common in that state, and it's the only state that has that so far as I know, that a spouse can claim virtually the entire unencumbered estate free of debt as part of the year's support. It's rarely challenged, but that's only in Georgia. It is an anomaly. Don't try that here in the DMV.
No, not at all.
Mr. Johannes, we got a real active audience. I love it.
Yes, we do. Here's an interesting one as well. If a sibling with no children and no spouse dies without a will but owns property, how long must the surviving sibling wait before they can obtain that property or funds to that probate? Or funds in probate?
Well, no, you have to go to court for any situation like that. And whether a sibling is entitled, it depends on the intestacy laws of each state. So you would have to petition to be the executor or the personal representative of the estate, and then that is the only person who can actually distribute assets, and it has to be in accordance with the laws of the state.
But let's back up a step and say, okay, I have a child, and or I am an adult, and I have no spouse and no children, but I've got one sister. That's a person who needs a will designating that their next of kin is their beneficiary of their estate. So you want to try to avoid that. That's an instance where a plan could make a difference.
Okay, I think we're going to stop with the questions right here for a moment. And
Okay. Let's see, where are we now? Factors to consider when making a will. I think we've covered most of these. Consult a reputable lawyer experienced with estate planning. Compile a list of your investments and assets. Include clear instructions. Communicate with your lawyer. Keep your will in a safe place. Ensure it can be easily found. Make sure that the executor knows that there is a will and how to find it. And let the person who you choose to be your executor know that they have been chosen to be an executor. Now, I think you could go either way on whether or not to tell your children there is a will. Unless they are the executor, there's really no real need for them to know ahead of time. That's more or less a personal decision. What do you think, Valerie?
Well, you know, I don't know about that, but a point I did want to make is, because I've had this too, where the original will has been lost, they can't find it. I don't know in all states. I know in DC that you can file a copy. However, the only way to do that is to get affidavits from the actual witnesses to the will to say, yes, I was a witness, I signed it in the decedent's presence. And that is another reason why it might be best to use a lawyer to do your will, because oftentimes the witnesses are their employees or people that can be reached after the fact. People have gone to banks, and those employees might have gone or disappeared, and they can't be found. So again, I think that is an important thing to consider when you're preparing a will. I don't know how many other states allow copies to be admitted, but it's important to make your original known to the executor or someone, and if not, to make sure that whoever witnesses the will are people that may be able to be found later.
Well, that is so true. Georgia does have a provision that allows for the admission of a copy if the original is lost. And it also has a provision that we call a self-proving affidavit. You can make the affidavit of the witnesses at the same time that you make the will, because that doesn't do you any good if you lose the will and lose the affidavit. But you don't have to go back and get an affidavit from those witnesses at the time of probate if you do the self-proving affidavit at the same time. And of course, now people are using videotape to make wills. More considerations. Who may be appointed executor? Seek permission. I wouldn't name somebody executor if they hadn't told me that they're willing to do it, because there can be a little bit of work involved in it. Family member, close friend, business partner, bank trust officer are some options. I've had people want to make their pastors their executors. I said, I promise you, your pastor does not want to be the executor of your will, no matter how much you love each other. Suppose all the parishioners in the church did that. Some qualities to consider is that, can the person be calm under pressure? If there is a dispute, can the person remain objective? Do they have any business or financial experience? Are they attentive to detail? And of course, are they financially stable? You don't want somebody who might be tempted to interfere with the assets in an inappropriate way to be the executor, because they're like a manager. To will or not to will, that is the question. Most folk, in my opinion, need some sort of basic will. There are many options to avoid the hassle of probating a will, but none of them covers everything. So that leaves us with the fact that a basic will is a safety net for anything that may not be neatly captured in other alternatives. And we'll talk about what some of those other alternatives are. Valerie, what are your comments?
Well, I agree with that. I think that even if you do a trust, and even if you have other alternatives for disposing of assets, a will sort of is a catch-all in case there's something out there. I mean, you might be an heir, and the will would take care of that. You might have forgotten something. If you do a trust and you forget to transfer something into the trust, it still needs to be probated. So that's why even a basic will, I think, is important.
I do too. Disinheritance. Wills can be used to include family members, and they can be used to exclude family members. There are some instances where there's a child or brother or sister or somebody that you want to make sure receives nothing from your estate. You must really be careful and work with a probate attorney to ensure that the language in the will complies with state law, and to make sure that that provision of leaving someone out of the will is enforceable.
I want to say here, though, that in most states, I presume, I know locally, you cannot disinherit a spouse. They can take against the will. You can disinherit, I think, everybody else, though.
Because most states have some provision for the spouse. Probate procedures. We've alluded to this all the way through. What exactly is probate? The purpose of probate is to prove that the will is valid. It's also generically used to refer to the process of administering a decedent's estate, assembling the assets, marshaling the assets, determining what the debts are, making provision to pay the debt, then distributing the net assets to the beneficiaries or the next of kin. All of that can be lumped under the term of probate. The laws of each state vary. So here again, we're telling you, I think for the third or fourth time, that it's a good idea to have a lawyer. Probate is required to settle outstanding debts, transfer property. This is especially true if the property has a paper title. Think about the things that you own. Your television doesn't have a paper title, but cars, boats, real estate, stocks and bonds, these are things that are evidenced by paper, and that's sort of a thumbnail sketch of what you need to consider in probate, because to transfer that document that establishes ownership from one person to another requires a signature. The owner can no longer sign because the owner is deceased. That is where probate comes in, and that's the purpose of it in a very general way. What's been your experience with that, Valerie?
I think that's true. That and you made a good point, and I think that goes back to one of the earlier questions, that only once a probate is opened and someone is appointed to manage the decedent's estate is someone in a position to even sign off on a transfer of title and to handle those assets.
How long does the probate procedure take? Well, it depends. And Valerie, you're laughing because you know what. Tell me what it depends on.
Well, number one, it depends on what state. For instance, I do mostly DC and Maryland. In DC, if you have a will, it is almost not administered by the court. Basically, you file the will, you file the petition, you get appointed, and the court steps out of it, and you have 3 years basically to get everything done. And theoretically, it can be done in a little over 6 months, because that's the period of time that a creditor has to come forward to say the decedent owed me money and therefore I want to be paid. In other jurisdictions, it really depends on the complexity. It depends on whether there are contests. But the bottom line is, if it's under the administration of the court, you know that there's a beginning and an end to it, hopefully, if someone isn't going to contest the will.
And there are time limits on the amount of time that someone can have to contest a will. In just about every state, your next of kin, your heirs, the people who would normally be considered to be the persons to inherit your property, are entitled to notice that probate is occurring, whether they're in the will or not. If your closest kin or your first cousins, they're all entitled to notice, even if only one of them stands to inherit under the will. But they can't go on and on forever and ever. They get the notice and they've got 30 days, 60 days to respond to it, to establish whether or not they want to contest, or there's a basis to consider contesting the will. I was laughing because generally, in my experience, what lengthens probate is disagreement among family members. The more people are aligned in their expectations, the more quickly sometimes probate can occur.
Correct. I've had, I think, one of the worst cases where two sisters had a disagreement about the disposition of one house. And they fought for years, and the legal fees exceeded $100,000. It was,
oh my goodness.
It was the worst thing I ever saw. But it happened. There was no will.
I think the worst one I ever saw was a small house in not very good condition. It had been owned for 4 generations by one family, but there had been no wills from one generation to the next. So you're talking about a piece of property that the family acquired maybe in the early 1900s, and here it is nearly 100 years later, and all of those people scattered from Oregon to the Bahamas owned fractional shares of that one small piece of property. It took years to settle, and unfortunately, the owners received very little because of the fees and expenses associated with it. So that's the kind of thing that you want to avoid. Contesting a will. The process is prolonged. We've talked about that. Can be very detrimental to the estate, particularly if the estate is not very large. Intestacy and intestate succession. Valerie, would you explain intestacy for our audience and intestate succession?
So that's basically a little bit of what my case that I was talking about. If you don't have a will, then the estate has to be administered by the court, and then the statute of the state that you live in determines who inherits your assets. And it can get complicated because there could be more than one person that's entitled to file the petition for probate. If everybody doesn't agree, then that person has to post a bond. It becomes supervised by the court. So that whole process makes it much more expensive than if there's a will. And those are the kinds of estates where you do have the most litigation around, because people are arguing about who's entitled to what. You have people that, in some families, there have been people that have been raised as a child or a daughter, but they were never formally adopted. You have issues like that. It can get very, very complicated. And that is just to say, once again, it's important to have a will.
All right, let's move on. Children, mine, his, and ours. If there is no will, state law, the intestate statute, determines which children inherit. So if I pass away and I have children, but I also have a spouse who has children, my spouse would get whatever the spousal share is, and the children share the rest. There is no provision for stepchildren in the intestate statutes. So if you want your stepchildren to inherit, there must be a will.
Right.
And there's a lot of variation among state laws. Louisiana's is totally different than any other of the southern states, for example. Many of them, in Georgia, the spouse takes a child's share, but not less than 20%. And there are different kinds of arrangements to take care of spouses and children and other relatives as well. I stuck this in here about Prince. I don't think they've settled that estate yet, and Prince has been gone from us a long time. State probate laws govern intestacy. We go through some of what states like Georgia, Louisiana, Alabama, sort of examples of how the intestate statutes work. I said in Georgia, it was the spouse can't take less than 20%. In Tennessee, it's less than the minimum share for a spouse is a third. This is the question that I used to get occasionally. And they say, well, if you die without a will, the state will take your property. Well, that's not quite accurate, because most state statutes, virtually all of them, are structured in such a way that if you don't have a spouse or children, you've got brothers and sisters. If you don't have brothers and sisters, you have aunts, uncles, and cousins. And that can just goes on indefinitely unless there's just truly nobody left of your blood relatives. Aretha Franklin's ex-husband wants a cut of her music royalties. Can you imagine that somebody as accomplished as Aretha Franklin is reputed to have no will or trust? Avoiding probate is legal and often good. Evading probate is not a good idea. Think about that family with the several generations. You just can't go generation after generation. Say, well, it's family property. Well, that means it's nobody's property. Some alternatives to a will include things like life insurance and trust and annuities and retirement plans, which are really, in a sense, contractual. They are contracts. Your life insurance has a beneficiary. The insurance company promises if you pay these premiums during your life, we will pay your beneficiary at your death. And so there's no need to probate that. Insurance proceeds are not part of the estate per se, at least not part of the probate estate. Valerie, any comments or examples on?
Yeah, the comment I want to make is that if you have something like an insurance policy or retirement or something like that, that you've named a beneficiary, make sure you update it if that beneficiary predeceases you. Because otherwise it could end up in the estate.
That's right. It becomes an issue at that point because they don't know what to do with it. Talks about Maryland. Now, this is, if you look at this, Valerie, and tell me whether this still sounds true to you.
I think it is.
Okay, so there is a small estate affidavit that if it's $50,000 or less, it sort of makes it a little bit easier to probate.
It does. One thing, and going back to this thing with Maryland, and I talked about the fact that a spouse could take against a will, and Maryland is one of the states that they can do that. And I actually had that in a case. And actually, the husband had signed the disclaimer in front of his wife because she wanted the property to go to her relative. He was a second husband. And he actually went into court after the fact and said, well, no, I signed that under duress and I want my share. And that ended up in litigation. So that's something that can happen.
Heirs and beneficiaries. We've talked about every state has laws that determine who your heirs are and what proportion of the estate the heir is entitled to receive. Those are the laws of intestacy. That does not apply when you have a will. The relatives are usually grouped according to the closeness of their relationship to the decedent. Children and spouse generally are in the same category. Siblings and parents are generally in the same category. Aunts, uncles, cousins are generally grouped together in a class. And as we all know, bank accounts, life insurance policy, financial portfolios, retirement accounts can have named beneficiaries, and those are ways that we don't usually put those in a will. I agree wholeheartedly with what you said. If you have a beneficiary, make sure you keep them up to date. And in most states, these assets, life insurance and other assets of that sort, where there are named beneficiaries, are not part of the probate estate and may not be liable for debts of the estate. Because remember, it's based on contract. Here's an example. Bill is married to Karen and they have 3 adult children. They own a house as joint tenants. Karen is also the named beneficiary of Bill's retirement account. So look what we've got. A house as a joint tenancy, that's going to go directly to Karen at Bill's death because that's the way joint tenancy works. And she's the beneficiary on his retirement account. Even if Bill has a will, she may not need to probate it because the major assets of the estate go to her without going through probate. But that would not be true of a house that is held as a co-tenant. Just because someone is your heir does not mean your child cannot just go to the bank and say, my mother has an account here, I need you to give me her money. It doesn't work that way. You will need, at a minimum, the death certificate, a photo ID, and letters testamentary or letters of administration from the probate court in order to access those bank accounts. What say you, Valerie?
Yeah, that's true. And if it's something that has to go through probate, then only the person that gets the letters of administration that's appointed to manage the estate gets to go and withdraw that money from the bank account, and that money goes into the estate to be distributed either according to a will, if it's no will, according to the laws of intestacy.
I agree. Let's stop and see, Mr. Johannes, do we have additional questions at this point?
Yes, ma'am.
Okay.
I'll start with the easy ones. Are there minimum assets in setting up a trust, and what is the cost?
There are no minimum asset requirements that I'm aware of for setting up a trust, and the cost can vary. Generally, in my experience, a trust is going to cost a few $1,000s. What do you think, Valerie? Does that seem accurate?
Yeah, that is accurate. There, as long if you have any asset, you can put it in a trust. That's up to you. And they generally do cost a few $1,000s. And again, it's just like a will. It depends on the complication of it. So the amount can vary, but trusts cover a lot more than a will. They're a lot. It's a much longer, more complicated document, so it's going to be much more expensive than a basic will.
That's true. But it does have more, in a sense, more functionality. It will do more things. It'll
Correct.
take care of you during your life. It'll manage your estate after your death. There's no, it can be structured in a way that there's no probate procedure associated with it. And so, and it's more time consuming than a basic wills, and that's why it's more expensive.
Well, I want to say this too. It's more expensive to prepare it, but it could in the long run be less expensive, because if you have a will and everything has to go through probate, then there's a cost associated with that, which might actually exceed the cost of the trust that you create prior to your death.
I hate to say it, but it's pay me now or pay me later.
Right.
Because the courts, when you file these documents, there are court fees that are associated with those, court costs, publication costs if necessary, service costs, in addition to the legal fees. So it can get pretty expensive pretty quickly. We talk a little bit about a healthcare power of attorney. Allows an individual to designate someone to make healthcare decisions. This can also be done in a trust, but this doesn't have anything to do with what happens after your death. A power of attorney has no effect after death. Put your faith in a trust. I was trying to be cute. You can do a generation skipping trust, which transfers assets from your estate directly to your grandchildren, sort of skipping over your own children who never take title to the assets. And that tax exemption for federal generation skipping trust in 2018 was $11.8 million in assets. It avoids estate tax, and the estate tax exemption for a spouse is unlimited. So you can be Mr. Bloomberg and transfer an unlimited amount of assets to your spouse without incurring any estate tax. Now, I am not a tax specialist. I don't play one on the internet. And so these are questions that you really need to take up with your lawyer and your accountant or financial advisor.
That brings us to the next question. Is there a way to have a child's education trust be handled by someone other than a living parent? Could a non-custodial person be given control of the child's education money, even though the child has a living parent?
I can't think of any reason why a godmother or aunt or somebody else couldn't be named as the trustee.
I don't
Can
know
you
if anyone couldn't either.
It doesn't have to be a living parent. As a matter of fact, a living parent might not have the capacity to do it or might not be as interested in doing it. We talked about a trust a couple of times already. It can help you avoid probate. It's more expensive than a will generally, but it could save you money, as Valerie indicated, in the long run, or save your estate money. The trustee owns the assets that are placed in a trust. Now, generally speaking, with a living trust, the trustee and the owner are the same person. Generally speaking, you can own the assets and also be the trustee. They're separate functions, but they can reside in the same person.
Here's an interesting question. What protection can you put in place to make sure that the spouse of your married child does not benefit from your child's inheritance?
You know, one of my friends asked me a question like that not too long ago. I'm not sure. I mean, obviously you can say, I only want my property is going to my daughter Susie. But once you give it to Susie, you can't stop Susie from giving it to her husband, at least not easily. I guess you could put certain restrictions on it. It's only to be used for Susie's medical bills, for example. It's only to be used to purchase a home titled in Susie's name only. But any of that can be undone. Can you think of a situation that would absolutely prohibit a son-in-law from obtaining property inherited by his wife?
No, I think the inherited property generally is not marital property, but I think you made the best point. Once the child gets it, it's theirs to do with as they wish, unless it's part of a trust that has restrictions on the use.
Now, what I've seen some families do is that they will trust that Susie gets more mature as she gets older, and so they will restrict the inheritance or the trust benefit until Susie's 35 or until Susie's, of an age where you think she'll make good decisions. But generally, the law frowns upon permanent restrictions on how a person uses property that belongs to them. And so you've got that tension in the law that makes it difficult to achieve that. Okay, this goes into a little bit about a revocable trust versus a irrevocable trust. Irrevocable means that it can not be changed. And the owner is the manager or the trustee, at least until his death. Are there other questions?
Yes. Will a bank account go into probate if your name is on the account, or if the person dies and there is no account as a beneficiary?
Generally speaking, if your name is on the account, the funds in the account go to the second or the other name on the account, and it's not a probate asset. Generally, it's considered to be a joint account. That word joint is a term of art, and it means that the survivor inherits the account.
If you are married with no children, if you are unmarried with no children, would you recommend a living trust or will?
If you're unmarried with no children, I would recommend a living trust or will. I think that because your heirs may be more attenuated. If you are not married and you have no children, then you're possibly looking at either brothers and sisters, nieces and nephews, or cousins as your next of kin. And the larger the group, the more opportunities there are for dissension.
What is the
So I
earliest age you should have a will drafted?
I'm sorry, I was talking and didn't hear that first part.
My apologies. I said, what is the earliest age you should have a will drafted?
Whenever you have assets.
Great answer. Even if you're under 18, if you inherit a big trust fund or you've got a big trust fund and you're under 18, somebody needs to be thinking about what happens if something happens to you. Other questions?
Some of these are already answered. I'm just giving them the direct answer from what you said.
Okay. A living trust, we've talked about a little bit. It's a written document that partially substitutes for a will. Depending on the nature and assets in the estate, it could completely take the place of a will, although I think both Valerie and I agree that having a will is a good idea. With a living trust, your assets are put into the trust, administered for your benefit during your lifetime, and then transferred to the trust beneficiaries at your death. They are of great value as part of estate planning, but as we've already talked about, not just to avoid probate, but because they're flexible, they can be private, and you have a little bit more control over the assets, and they can accomplish more of your goals because a will only takes effect at your death. A trustee of a trust is simply a manager of the trust assets, and you can designate a trustee as well as a successor and co-trustees. Although, make sure that if you're naming co-trustees, I'm not sure that I recommend it in most situations because those people need to work together as a team, and if they have different points of view or get into a conflict, that can throw the entire estate plan into chaos. Ms. Carpenter-Luria, do you have any comments about trust and how they can sort of get turned?
No, not any more than what we've already said, but I do agree with you that I would generally counsel against co-trustees. Sometimes people have children and they don't want, one child to be upset if they name another child, but it generally makes it more difficult if you have more than one person trying to make decisions.
And even if they're in agreement, it's logistically more difficult because you've got to arrange for two people to get to the probate court at the same time. You've got to arrange for two people to meet with the lawyer at the same time. So it just makes,
right, go ahead, sorry.
I was just gonna say, it just makes the process more cumbersome.
Right.
The assets in your trust pass to your beneficiaries. The trustee manages the trust assets after your demise. The trust assets do not have to go through probate. The trustee, the successor to you as trustee, pays the bills, the taxes and expenses. The trustee pays out the bequests and closes the trust. If there are minor beneficiaries who don't want to receive their money, or there's a provision in the trust that they don't receive their funds until they come of age, the successor trustee can create new trusts for them from your original one. Now, Valerie, I know that you have been involved in the administration of estates where there are trust assets, and you had to make sure that those assets get passed along to the proper beneficiaries. Talk to us a little bit about that process, if you will.
So basically, the trust will instruct the trustee as to how to manage the assets. And basically, you have to trust that the trustee is going to honor your wishes, especially if it's unsupervised in any way. Because remember, a trust does not get filed with the court. There's no oversight, no supervision in that way unless someone challenges it. So basically, the trustee is responsible for using the assets the way you've instructed. And if there comes a time when all of the assets are to be distributed, then that trustee has to be trusted to make that distribution as you requested. And so you really want to pick someone that you trust, that will follow your instructions, and you trust will manage your assets the way you would manage them yourself if you were alive.
One of the purposes that a sound estate plan can achieve for us is to leave a legacy. Many of us have causes that we believe in deeply: the environment, our favorite HBCU or sorority or church. One of the ways of expressing that sentiment is to leave a legacy gift or planned future donation given through a will or trust or other form of designation. Planned giving is a way of honoring the things that are important to you during your life and helping them to continue after your demise. They can take the form of a bequest in your will, or a trust provision, a charitable gift annuity. A lawyer with experience in trust and estates can help guide you through this process of leaving something behind, not just to your family and friends, but to advance a cause that you believe in. Mr. Johannes, are you still getting questions?
Yes, ma'am.
Well, we're about to the point where we're going to close out in a few minutes. Let's take these last 10 minutes or so to answer any remaining questions.
What is the best attorney to identify to help you with your probate? What kind of attorney should I be looking for?
You should, there are many websites. Lawyers.com is one that comes to mind. And basically you can put in, I'm looking for an estate attorney. You always pick someone that's in your jurisdiction. And then they generally will point you to websites and reviews and things like that, but you want to try to narrow it down to what your goal is. If you're looking for a complicated trust, then pick a lawyer that has experience in that. If you're looking for a basic will, maybe you don't need to pick someone from a large firm that has a lot of estate planning and financial planning experience, because a basic will doesn't require that. So I think that is the thing you should do, is to make sure you narrow the search down to someone who meets your specific needs. And then you need to meet with them to make sure you're comfortable with them. You feel confident in the advice you're being given, and you don't necessarily have to stick with the first lawyer you interview.
I agree with all of that. That is great advice. Are there other questions?
Yes. What if you, with the proceeds of your life insurance to go to multiple people, but it's not in your probate?
Okay, well, your life insurance under normal circumstances would not be part of your probate estate. And you are allowed, I think virtually every life insurance policy will allow you to name multiple beneficiaries. And you can do that generally in two ways. You can do it either as a percentage. There's a $100,000 life insurance policy. You can leave 5 people 20% of that. Or you can designate a cash amount that they are to receive. But most insurance companies will allow you to name multiple beneficiaries. And under normal circumstances, that would not be subject to probate at all. Is that it?
What does it mean the special trust for an adult states the beneficiary has rights to the income and principal?
Could you repeat that one? I had a little bit of difficulty hearing.
What does it mean when the special trust for an adult states a beneficiary has rights to income and principal?
Okay, think of your assets inside your trust basket in two ways. To simplify, we'll use a rental house. there's a piece of real estate. It's a residential piece of real estate. That is the trust asset. But that trust asset generates revenue or income through rents if it is rented. And so while the principal is the house itself, the income is the rent. And that could be true of stocks or bonds. Many assets are capable of, you can own timber, and the timber is the asset, and what you earn when you cut the timber is the income from it.
If I die before my divorce is final, can the will determine my assets go to the child? We've been living separately for a long time.
In
Well,
that
there is
circumstance, I would get a separation agreement that says the spouse that you're separated from has no interest in your estate. That's the only way to protect it.
I agree. There's no such thing as a common law divorce. No matter how long you're separated, it doesn't dissolve that marriage.
If the parent passes and leaves the house, do all the children get equal rights, and can one child sell it without the permission of the others?
Yes and no. All children share equally. No child can sell it without permission, or at least notice to the others, and probably permission from a court.
My husband is on my mother-in-law's checking account. In the event of her passing, legally is he the account owner, and by default does he split it amongst his siblings?
You can own a bank account, either the person is on it for convenience or they're on it as a joint owner. So it depends on how they have the account set up. I have seen circumstances where a parent will choose one child to go on the bank account, and with the expectation that they're going to divide the money when they die among other siblings. But unless the account is set up so that it's joint owned, you're going to leave it up to that kid to honor the parents' wishes.
And I think that the default, the general principle is that it would be set up as a joint account, and it would go to the person who's named unless there's some provision to the contrary, and that can be very result in unexpected results. I agree with you, Valerie. It's
right.
Something to be careful about.
Right, because that would not be, if it's a joint account, it's not going to be a part of the probate, and therefore it will be a voluntary act by the child to share it with his or her siblings.
Can free legal services like legal aid help you establish a basic will?
Yes. If you meet their qualifications for their services, yes.
If you designated beneficiaries for your money market account fund, does this have to be probated as well?
No. These are good questions.
I've had several people ask, can you send me copies of the slides? The slides are already in the handout portion and in the email that you received, as a reminder that this was going to happen an hour ago.
If you see that thing that looks like an Adobe Acrobat symbol, that red little red square with a white squiggly thing in the middle, if you click on that, the estate planning program guide, it should download to your computer if you're using a computer or even a smartphone.
And the rest of the statements are thank yous.
Well, you're welcome, and thank you for joining us. And Ms. Valerie Lurie, Carpenter Lurie, do you have additional final comments you would like to make? We're so grateful that you would join us. It's just a pleasure doing this with you tonight. And we hope that people got something out of it. I'm sure they did.
Yes, just how important it is to follow up with this. And I think one of the things that was said before about legacy giving, one of the things that I was involved with when I served as a trustee was a parent who requested that their not quite competent child be taken care of during his lifetime. And then after he died, that this person chose certain charities, her church, that she wanted the balance to go to. And I think that that could be an important thing that if you guys are in that kind of situation, that you might want to consider.
Well, thank you all very much. We do these webinars twice a month. The next one will be the second Thursday night in March. I'm not looking at a calendar, but let's see what that date is. It will be March the 12th. And we invite you to come back and join us again. And we hope that you will consider joining the National Council of Negro Women. We're celebrating 85 years of existence. If you're in the DC area, stop by and see us at 633 Pennsylvania Avenue. We're the only Black-owned building on Pennsylvania between the Capitol and the White House. With that, I will say good night and thank you to each of you who joined in, and especially to you, Valerie, for being such a great partner tonight.
Thank you.